Again, Professor, thank you so much for being here. Right now in Sweden, it's 1:30 p.m. In Taiwan, it's already 7:30 p.m. evening time. So huge difference. And I'm glad that we have possibility to communicate through online. I also, before I start your lecture, dear Professor, I also would like to say thank you for the host of this online session, to the School of Law at National Yang Chiao University, especially to Professor Thomas Chen, that he is also a Dean of School of Law. And also this online session is possible with the help of Center for Digital Governance and Legal Innovation at National Yang Chiao University. Thank you so much for support in the online session. And I'm very happy that Professor agreed to be a guest lecturer for this very interesting topic about companies as agents of artificial intelligence governance under the proposed AI regulation in the European Union. Professor Eduardo Gill-Pedro is Associate Lecturer in European Union Law. He is also Research Fellow for Ragnar Söderberg Research Fellow Program, and also working as Associate Senior Lecturer in Law and Artificial Intelligence at the Faculty of Law in Lund University in Sweden. So I'm really very excited to hear about this very relevant topic for now, and especially relevant for for this time when smart technology became very crucial for all of us, and very important to discuss about this. I'm looking forward after, as you, Professor, will complete your lecture. We'll have a question-answer session. So please, dear audience, dear students, please don't hesitate to ask Professor if you have some questions. I believe that we can have a great discussion about the appointed topic. Please, Professor Eduardo Gill-Pedro, time for you. We are looking forward to hear a little bit about you, and of course, to hear your lecture as well. Please.
Great. Thank you very much for inviting me. It is an honor and a privilege to be speaking to you. I haven't been to Taiwan and I haven't taught in Taiwan, but it's really exciting to be reaching out to you from Sweden here. Lund is in southern Sweden, and I'm as Daria, as Dr. Bulgakova mentioned, I am associate professor in EU law. So EU law is my field of expertise. But I also have a project on both on companies and companies' rights, but also another project on law and AI and the role that AI plays in the governance of companies. So I'm going to be talking to you today. I'll start my screen if this works. We tried it before and it did, so hopefully hope you can all see my screen. So that's our building here in Lund, and companies and the AE and the EU AI regulation is the sort of short title of this talk. And this is going to be a new lecture for me as well as for you, because this is all very new. So the regulation is still not law yet; it's still a proposal, and we're still all trying to figure it out. And it's still not in the curriculum yet here. I'm a director of a master's program in EU law here. And I run several courses, and we still haven't integrated this. We're in the process of doing that, but it's good to know that you in Taiwan are ahead of the curve in engaging with this EU regulation. So the way I thought I would structure this is, first of all, just tell you very shortly about the proposal, where it's at, and then give you an overview of the EU legal order. I think this might be helpful to try and understand this regulation in the broader context of the EU as a legal order and how it works, because it is quite a complex and quite peculiar legal system, the EU. And I know that you have studied aspects of EU law and transnational law and international law, of course, but I think that to just look specifically at what a regulation does might be helpful as a starting point. And then I will give an outline of the regulation, and I will focus in particular on the burdens that this regulation and the obligations that this regulation imposes on companies. But I will also look more generally at the objectives of the regulation, at the material, personal, and territorial scope of the regulation, the kind of regulatory approach that this regulation adopts, and the governance and enforcement mechanisms that there are. And I will say something about, perhaps sort of to open it up for our broader discussion with Dr. Bulgakova. We will open it up. I will touch on whether this represents a new regulatory paradigm. So whether the way of regulating AI brings something new to the table. So that's what I propose to do. There will be a discussion and questions at the end, but if at any stage there's something that I'm saying that doesn't make sense to you or that you don't understand, feel free to raise your hand. I'm not familiar with this WebEx system, but I imagine there's some kind of digital hand that you can raise. If not, just turn on your microphone and shout out and interrupt me. So if you don't understand anything, do that, but otherwise we'll have questions at the end. So, okay, the proposal for an AI regulation. This as I wrote a piece in the Nordic Journal of European Law last year when this came out, which I circulated, sort of suggested this as optional reading. It's by no means obligatory. But I claimed that this was perhaps the most important legislation facing humanity. I was a little bit tongue-in-cheek in that, but it is intended to be the first binding legal act regulating AI at a transnational level. And even, the US doesn't have anything, the major European states don't have anything. So there isn't a lot of regulation of AI out there. And if this is approved, it'll be the first legally binding regulation on AI. And the idea of the EU is that this is going to in some way set the pattern for how AI is to be regulated in the future. So this will lay out a model of regulatory oversight for AI that will not just impact EU, but it will have an impact beyond the EU. And one way in which it's thought that this might work is by the so-called Brussels effect. I'm not sure if you've heard of this, but it's applied primarily in relation to the Data Protection Act, to the EU General Data Protection Regulation, where because the EU sets such strict rules on how data is to be regulated and data protection is to be regulated, then other countries that wish to trade with the EU and engage with the EU, they also adopt those rules rather than having separate, than adopting weaker rules. And this is a parallel to the California effect that happens in the US, where California has very high, stringent regulations for cars. And so if companies based in other states, say in Ohio or in Michigan, want to export internally within the US, cars to California, they have to adopt to the rules of California. So in the end, cars are always made in compliance with the stricter rules in California. And I suppose that's the ambition for the EU here, is because they are setting quite strict rules for AI, then all AI producers, whether they are in the EU or not, but who may have an interest in trading with the EU, will adopt EU rules and comply with a stricter EU level. And in that way, the EU norms will be exported to other states, such as Taiwan, for instance, if Taiwanese companies want to provide AI to the EU. And in that way, it's intended to shape the future of AI regulation, not just in the EU, but across the world, that this will be the way in which AI is regulated. That's why I titled the paper the most important piece of regulation, of legislation facing humanity, because the ambition is there that this will be a kind of Code Napoleon, a sort of Napoleonic code for the global regulation of AI. Whether the EU will do that or not is yet to be seen, but that's the ambition. Okay. Now let's look just a little bit of background on what this thing called the EU is. You know that it is based on an international treaty, in fact, 2 international treaties between what is now 27 member states. It used to be 28, but now the UK has left the EU, so now there's 27 of us. This has it's been going since 1957, where it started as a European Economic Community, but it now covers a much wider range of activities than a merely economic community, and it's grown to be one of the most influential international organizations in the world. It's actually one of the most influential regional international organizations in the world. And the way in which it works is that member states have effectively pooled their competencies in order to achieve common objectives. So there's this idea that member states gave up their sovereignty when they joined the EU. That was sort of part of the discussion in the UK when they were considering leaving the EU. But this is a misunderstanding. Member states are still sovereign, but they transfer part of their competence to the EU, where the EU needs those competences to attain the objectives that are set out in the treaties. So the member states agree on a number of objectives, and then they say, we transfer some competence to the European Union in order to achieve those objectives. If they don't transfer the competences, they're still with the member states. And most importantly, if the EU, if a measure cannot be seen to be necessary to achieve an objective, then the EU doesn't have the competence to do it. So the EU can only act where this is necessary in order to achieve an objective. So when you think about a regulation like the AI regulation, you need to think, why is the EU regulating? What is the objective that's pursuing? And we'll talk about that. But just so that you know, the objectives are always very important when we think about EU law. The central objective still, even though the EU is no longer just a European Economic Community, the economic objectives are still very important. And the central economic objective is the creation of an internal market. And this is meant to be much more than a custom union. So in East Asia, for instance, there is a community there, which is essentially a customs union, ASEAN. And that means that trade barriers in respect of customs duties and quotas are taken away to a significant degree. But an internal market is a lot more than just a customs union. An internal market is, in the words of the treaty, an area without internal frontiers in which the free movement of goods, persons, services, and capitals is ensured. And that means that for somebody, a company based in Sweden wants to sell products to Portugal, it should be just as easy and should have just as little obstacles as if they want to sell it to another part of Sweden. Or if I, as a Portuguese person, want to travel to Bulgaria to work, then it should be just as easy for me to get work there and have work on the same conditions as if I'd stayed in Portugal. So that's the idea. And so this is a very ambitious project and one that requires a great deal of intervention by the EU in order to shape the EU member states, so the different 27 member states, to shape their legal orders in a way that will allow this to work. Because if you think about it, if you want to remove obstacles, then you need to decide what is an obstacle and who decides what amounts to an obstacle. Of course, if the member states decided it, then they would say, no, this is fine. So you need to give the power to decide what counts as an obstacle to free movement to an EU organization. And the institution that has the power and the competence to interpret the treaties and decide what kind of things are and are not obstacles to free movement is the Court of Justice of the EU. And you have a picture there of the Court of Justice and all the 27 judges plus advocate generals that interpret authoritatively the treaties and the EU legal acts and decide what is and what is not an obstacle to free movement. And what they've told us back in 1974 is that all national measures capable of hindering directly or indirectly, actually or potentially, intra-community trade are prohibited. And if you think about national measures that can hinder, can sort of make it more difficult for trade or free movement of persons or free movement of capital or of services, either directly or indirectly, actually or potentially, what this means is pretty much every national regulation on the market is an obstacle to free movement, potentially. And what is more, the EU has some peculiar characteristics that mean that it's quite a lot more than an international treaty. So if we use that case of Dassonville as an example, Dassonville was an importer of whiskey that wanted to import whiskey into Belgium. And there was a Belgium law that meant that it needed to get some kind of authorization, some kind of certificate. And this is an obstacle to free movement, as the court said, because actually or potentially, directly or indirectly, it makes it more difficult for imports to come into the market. If this was a normal international treaty, the only thing that the importer could do is ask its member state or ask another member state to challenge that breach of the treaty by Belgium. Because treaties, the only entities that can normally, with normal treaties, the only parties to the treaty will be the states that signed the treaty, and this would mean that an individual would have no recourse effectively. But what the EU did, what the Court of Justice decided, is that EU law had direct effect. And that means that this trader in Belgium could go to the Belgium court, to the national court in Belgium, and say, this Belgium rule is an obstacle to free movement. It's prohibited by the treaty. And the national court had an obligation to give effect to that free movement right of the individual and to set aside the national law. And this means that individuals, by challenging rules in national courts, can enforce EU law and can require national courts to set aside national law. And this can be a tiny court in a member state can set aside, can disapply, can set aside an act of parliament of that state or a decision of the Supreme Court of that state. So this is a very powerful tool to enforce EU law. And what's more, the EU system has this preliminary reference procedure which allows national courts to ask questions of the Court of Justice. and to get the Court of Justice to say the treaty requires you, national authority or national court, to set aside this national law, and that empowers national courts to effectively disapply national law to give effect to EU law. So this is a very powerful tool, but what that means is that national authorities and national governments might not be able to regulate the market, because any regulation that they introduce is likely to be an obstacle to free movement. So, for instance, Sweden might have quite strict rules about how toys are to be manufactured because it wants to protect Swedish children from dangerous toys. And there might be a company in another member state that makes quite shoddy toys and has to comply with a lower standard of toy safety in that country, that wants to export those toys from that country to Sweden. Sweden, under this rule, under the rule of Dassonville, will in principle not be able to stop the importation of these toys. There are some possibilities to derogate from that prohibition on obstacles, but generally the prima facie rule is member states cannot create obstacles to free movement. And this is a problem because obviously Sweden wants to protect its children from dangerous toys coming from other member states. So how are we going to resolve this problem? And the way in which the EU has to resolve this problem is by saying, okay, you member states can't introduce separate rules, but we, the EU, together can introduce common rules that will harmonize the legislation of all the member states and ensure both that there's free movement and also that these important interests like protecting children from dangerous toys are safeguarded. And the way in which it does that is by creating legislation such as regulations and directives. And these two institutions I've got here is the European Parliament and the EU Council, not the European Council, not the Council of Europe, the EU Council. There's sort of quite a lot of councils in Europe, but these are the two legislators that make all laws in the EU. The Council of Ministers represents the member states. The European Parliament represents the citizens. They are directly elected by the citizens of the member states. And that means that when legislation is made, it is legislation that is made with the approval of all the member states through their governments and also of all the people of the EU through their representatives in the European Parliament. And therefore, this legislation has legitimacy and reflects the understanding and the views on what a good level of safety, say for children's toys, will be to apply across Europe. Okay, that was a very quick run through the structure of the EU law. Are there any questions at this stage before I turn to the proposal? No? Okay.
Thank you so much, Professor, for this introduction about how actually European Union laws work. I think it's very important to understand that in general, Europe tried to unify its member states to work together for the benefits and for the values that you mentioned in the beginning of your lecture.
Yeah.
I think it's quite a great point. Thank you so much for this part of introduction.
Okay.
Yes, if anyone have some questions at this part, please ask, or if you feel not comfortable to ask, you can also use chat, so I can help to introduce your question to Professor Eduardo Gill-Pedro. Thank you so much. Please, Professor, we are looking forward for the next part of your lecture.
Okay. Right. Now let's dive into the regulation, because the regulation that I introduced is a regulation of the European Parliament and of the Council, which lays down harmonized rules on artificial intelligence. So it's just this kind of instrument that I talked about, because it might be that, and in fact I know that Sweden was thinking about introducing regulations, or was discussing about whether AI needs to be regulated. Maybe France was thinking about that. Italy was thinking about that. And if all these different member states introduced different rules, you wouldn't have an internal market. You would have 27 different internal markets. So to anticipate that and prevent fragmentation, what the EU did was to make a proposal for a regulation of the European Parliament and the Council, which will harmonize all the national rules on artificial intelligence. In fact, at this moment, there are no such national rules, but this is kind of jumping the gun. In case the member states are thinking of introducing rules, we will harmonize them, and then that takes care of things and will stop any fragmentation or partition of the internal market in advance. So this is a proposal, and who makes the proposal? The Commission makes the proposal. That's another, the third institution. The fourth institution. We talked about the Court of Justice, we talked about the Parliament, the Council, and the fourth institution is the Commission. That's a bit like the civil service or the executive for the EU, like the government of the EU. And they are meant to act in the interests of the EU. And the president of the Commission, when she was elected, or in fact when she was campaigning to be elected, one of the promises that she made, and this is Ursula von der Leyen, you might have heard of her, she's in the news quite a lot. One of the proposals that she made is, within 100 days of my coming into office, the Commission will put out a proposal for a regulation on AI. And this is what has happened. This came out in July of last year, 2021, so shortly after von der Leyen came into office. If this is not yet law, so this is still going through the Parliament and the Council. They are debating this, and there are lots of amendments being proposed. So what I'm dealing with is a little bit of a moving target, in that we're going to be talking about details of the proposal, but you should be aware that it is possible that some of these things will change. But I don't think that they will change fundamentally. I've been following the process quite closely, and I don't think that it is likely that we will deviate very much from the structure that we have now. And this is a proposal for a regulation, and that's important to just have a think about what that means. A regulation is a directly applicable instrument. That means that it is the most powerful harmonizing tool available to the EU. In contrast with the other instrument that the EU can use to harmonize, a directive, a regulation doesn't need implementation. So with a directive, the EU publishes a directive and says the member states need to transpose this, need to implement this in national regulation, in legislation within, say, 2 years' time of this coming into force. And what that means is that the member states, say Sweden or Italy, need to make law that will effectively bring in the directive into national law. Transpose it into national law, and then once it's transposed into national law, then it'll bind individuals and organizations. A regulation is different. A regulation is directly applicable, which means that as soon as it's published in the official journal, in principle, then individuals and organizations will be bound by it. This particular regulation actually has a 2-year grace period and says this will be valid from the moment it's approved, which probably is going to be sometime around this time next year, maybe beginning of 2024. But as soon as it's approved, it's not going to be applicable immediately. There'll be a 2-year grace period, which means that individuals and organizations have time to adapt their procedures and the way they work to make sure that they comply with this regulation. That was the same with the GDPR, the General Data Protection Regulation, where the EU gives some time to to companies and organizations to adapt to the new legal landscape. So now let's look at the Act in more detail. The purpose of it is to improve the functioning of the internal market. As I said, this is a provision that fits under the regulatory framework of the internal market. It's made under the legal basis is Article 114 of the Treaty on the Functioning of the EU, which is the provision that gives the EU competence to legislate in order to facilitate the functioning of the internal market. And this is what it does. The purpose of it is to make sure that the internal market works by laying down uniform rules about how AI is to be developed, marketed, and used in conformity with union values. And that gives us a hint of the fact that there's something else behind. Because, and this, before I go into the specific objectives, just a general point, that the EU has these objectives of, say, creating the internal market and has the competence to harmonize national laws in order to achieve this objective. But it has quite a lot of choices on how it chooses to do that. So, for instance, it could harmonize it by saying there are no rules that apply whatsoever. Member states are prohibited from regulating AI at all, and it'll be a free-for-all. That'll be one way that will improve the functioning of the internal market. For instance, a good example is the tobacco regulation. For instance, the EU could have decided, we don't want any rules governing tobacco. We want everybody to be able to trade freely in tobacco products, and there not to be obstacles to free movement of tobacco products. But the EU doesn't just have those objectives set out in the treaty. There are also set out those specific objectives. It also has other provisions that say when the EU acts, it must do so in light of these other considerations, these other interests. And these interests include protection of human health, they include protection of the environment, protection of the consumers, and it includes, very importantly, protection of fundamental rights. So the European Union has a Charter of Fundamental Rights, and whenever the EU acts, it has to act in a way that respects and upholds the fundamental rights set out in the Charter. And that means that when the EU proposes a piece of legislation like this, in order to achieve the objective of the internal market, it has to do so in light of these other important interests and values that are also in the treaty, such as protecting consumers, protecting the environment, protecting public health, and protecting fundamental rights. So, in light of that, the specific objectives of this AI Act are facilitate the development of single market for AI products and services, so the whole 114 harmonizing objective, but also ensure that when AI is marketed and used, it is safe, it respects fundamental rights and union values, and it complies with union law. And finally, this is an important point to bear in mind, that this is not something that's been created in order to stop AI being developed, or in order to that just has the ambition of protecting people from AI. It sees the value in AI, sees the value in companies being able to develop and deploy and use AI in a wide range of industries and applications and areas of society. And it wants AI to be used and there to be innovation and new ideas to come out. But it wants to do that in a way that is safe, respects fundamental rights, and complies with its existing laws. And the idea is if the industry and companies know what the rules are and can see a very clear, predictable regulatory framework, then they will be more likely to invest and to engage in AI innovation, because they can be confident that whatever they do, if they just follow the rules that are set out, they'll be able to market it throughout the EU. And remember that the EU is a very big market. It has 450 million people at the moment, so the member states of the EU, and they are also generally quite wealthy countries. So it is a very good market to have access to. So if one knows that if we comply with these rules, then we will be able to innovate and to be creative and to introduce new products into the EU market, that will be a profitable undertaking for companies. The tagline that the EU and President van der Leyen has chosen for this approach to AI regulation is trustworthy AI. So the idea is by having clear, predictable rules that will ensure safe AI that respects fundamental rights, but at the same time facilitates and allows for innovation, that this is a way of getting trustworthy AI, getting citizens and industry to trust in the AI and in the systems regulating AI. Okay, now let's get into the scope of this regulation. It regulates AI in the sense that only what is AI falls under its scope, but it doesn't necessarily regulate all of AI, but I'll come to that in a minute. But first, what is AI in the Act? It is software that can, for a given set of human-defined objectives, generate outputs, such as content, predictions, recommendations, or decisions, influencing the environments they interact with. So there has to be an ability, a system, a software system that is able to perceive the environment in some way, is able to interact the environment, and is able to generate outputs that are able to influence that environment in some way. This is a very general definition that covers a lot. There are a number of types of technologies that are specifically mentioned in Annex 1. And this includes machine learning approach, which is what neural networks, etc. That's what one thinks when one thinks about AI these days. But it also includes other older approaches to AI, such as statistical approaches and logic approaches. So it casts the web very widely. So it's not just the kind of neural networks, machine learning stuff that one thinks of when one thinks of AI these days. So back. So once we've established the kinds of things that are regulated, the material scope, we need to think about the personal scope. And the key player in the regulation is the provider. And providers are any natural person, natural or legal person. It won't be a natural person. So you and me are not going to develop AI systems. It's going to be a company or an organization or a university, something like that. So it might be a public authority, might be an agency. Most likely it's going to be a private business company. Certainly in Europe and perhaps even in Taiwan and in the US, it is likely to be a business company that will be the provider. And the provider is any entity that develops an AI system or has an AI system developed with a view to placing it on the market or putting it in service under its own name. So if we want to give an example, say if the Institute of Computer Science and Engineering at the National Yang Ming Chiao Tung University develops an AI to be used in, say, an educational setting, say to mark exams, for instance, and then it exports and markets that AI system under the NYCU brand, then NYCU will be the provider because they have developed that AI system. But also, if, say, NYCU commissions a quantum computer to develop an AI system to be used in an education setting and it exports it to Europe, then NYCU is the provider still, even though it was quantum computer that developed it. But if it is put into service or marketed under the trademark of NYCU, then NYCU will still be the developer. Does that make sense? Okay. The other entity, which is less important and less significant, but still quite important, is the user. And this is, one might think that the user might be you and me that sort of make use of AI or other subjects of AI, but it's not. It is still generally not natural persons. It's quite often legal persons or public authorities, agencies, other bodies that are using an AI system under its authority. So, for instance, let's continue with the example of NYCU having developed this educational AI, and Lund University buys that AI from NYCU and uses it to mark exams of its students, for instance. Here, NYCU is the provider, of course, it's being marketed under its own name and it developed it. Lund University is the user. So the entity that's using the system under its authority is the user. The students, who are the targets of the AI and who are the subjects of decisions made by the AI, they don't count. And this is what's quite different between this system, this type of regulation, and something like the General Data Protection Regulation, the GDPR, where the subjects, the data subjects, are given a very wide range of rights and can use the GDPR to act and to enforce their rights directly against data processors and data controllers. Here, individuals who are subject of decisions made by AI don't really have rights under this regulation. There is a liability, AI liability directive being going through Parliament at the moment that's meant to provide rights to individuals, but it doesn't fall under this regulation. There's also the possibility for the user to become a provider. If the user places on the market an AI system under their name or trademark, or they modify the intended purpose of a high-risk AI system, or they make a substantial modification to the high-risk AI system. So again, if I continue my example, say Lund University has bought this educational AI from NYCU, but wants to market it to other universities here in Sweden under the Lund University brand, then that will be instead of just being a user, Lund University would now be the provider. Similarly, if Lund University buys this AI from NYCU, but decides to not just use it to mark exams, but decides to use it to check employee attendance, for instance, so changes the intended purpose of this AI, then they will no longer just be a user, they will become a provider. Finally, if Lund, having purchased this AI from NYCU, decides to add some elements to it that will allow much closer monitoring of the students, for instance, and this amounts to a substantial modification of the high-risk AI. What's a substantial modification is defined in the regulation. We don't need to go into too much detail on that. But if it does do that, then again, it'll stop being just a user and it'll become a provider. There are other just on the geographical scope, and this is important for companies based outside the EU, because both users and providers can, well, certainly providers if they are, even when they're not established in the EU, if they are established in a third country, say if they're established in Taiwan, they will be bound by the regulation if that system is placed on the market or put into service by that provider. Any user of an AI system which is located in the EU is of course bound by the regulation. That's not surprising, but perhaps more surprising is that both providers and users of AI systems that are located in a third country will be bound if the output produced by the system is in the Union. So again, let's use this example of an AI developed by NYCU, and Lund University asks, contracts out, say, the marking of exams to NYCU, and you use your AI to mark the exams of students here at the Lund University. I don't think this is likely to happen, by the way. This is a fairly far-fetched example, but just to sort of give a picture of the relationships here. So there will be a system which is being provided by a organization, by a company, or by a university based outside the EU. The user that's using that system in order to mark exams is also outside the EU, because the user is the one that's using the system to do the marking. But the output produced by the system, so the decisions about what grades the students get, that falls under the EU. It's here in Sweden that the students are placed, and the decision is affecting those students here. And that will be a system that will still fall under the regulation, even though both the provider and the user are located outside the EU. So you can see this is quite a broad extraterritorial scope, and might have an impact in companies in Taiwan and in lots of other countries. In addition, just to finish off on the personal scope, importers are covered, and that is, those that import the AI service, but they must be established in the Union. So you can only be an importer if you are based in the EU and you bring it in from, say, Taiwan or from some other third country. And distributor, but distributor means any national or legal person in the supply chain other than the provider or importer that makes it available on the Union market without affecting its properties. This might even be, a distributor might even be somebody who is not in the EU. But these terms are still being defined, but you hope this gives a picture of the range of actors and also how impactful this potentially is for actors outside the EU. Okay, that's it in terms of scope, both material scope, geographical scope, and personal scope. Now let's look at the regulatory approach that this proposed EU AI Act will take. And what the Commission chose is what's called a risk-based approach. And that means that it's not the technology that is regulated per se, but it's certain high-risk-based applications of the technology that are regulated. So it's not a blanket cover on all AI technology, but it focuses on the riskier applications of AI. And the Commission has given us this very colorful graphic to try and understand that. And you'll see that it's a pyramid, and that is meant to be that at the top there's a small amount of applications, underneath larger, and then yet larger and yet larger. And you can see that at the bottom, minimal risk applications that are effectively not subject to any regulatory control at all. That is meant to be the bulk, the majority of the AI applications. So the idea is that most AI applications will not be subject to any regulatory oversight at all, or have any obligations imposed on suppliers, users, importers, or distributors. On the other hand, at the top of the pyramid, there are certain types of applications that are considered to be an unacceptable risk, and those are outright prohibited. There's only 4 of them. Let me just check. Yes, and I will go through them. So the prohibited applications are those that subliminal techniques which distort a person's behavior and are likely to cause harm. There's been a lot of discussion about what this means. I mean, is a recommendation algorithm on YouTube or on TikTok a subliminal technique? It's not quite clear. Exploitation of vulnerability in a manner that distorts a person's behavior and is likely to cause harm. Again, this is vulnerability is like children or people with some kind of other vulnerability, psychological vulnerability that made them more subject, more likely to be exploited. It's unclear, but I think the threshold is going to be quite high here. It's going to be deliberate attempts to manipulate people without their knowledge in order to change their behavior and in order to intentionally cause them harm. There's also real-time biometric identification systems in public spaces, although I just read this morning that there's a proposal to take out the public spaces and to also include private spaces. But this is effectively facial recognition or gait recognition in public spaces where there will be cameras that will be able to identify biometrically identify individuals. This is in principle prohibited unless there is you need to find a missing person or there's a terrorist attempt taking place, but there can't be general biometric real-time ID systems in public spaces. And also the social scoring systems. There is a system being used in the People's Republic of China that has been sort of subject of quite a lot of discussion in Europe concerning social scoring, and this is seen as something that would not be compatible with EU values. So the EU wants to make it clear that this would not be allowed in the EU. But they're very small number of applications, limited risk of application. So in the pyramid, it's this purple bit here, dark purple bit. They include chatbots. For instance, if you're engaging, going to a website of a online store, and there's a chatbot, can I help you? There has to be made clear to the customer that that chatbot is an AI and it's not a real person. So there's this transparency obligation. Deep fake. So if you use AI to make a recreation of Angelina Jolie and President Biden kissing, it's you have to tell this is a deep fake made for comedian purposes or whatever. It's not really Angelina Jolie and Biden kissing. So there's a transparency obligation in that respect. Emotional recognition of biometrical characterization. This is very weird that if you use an AI to see whether somebody is somebody's age, gender, sexual orientation, political opinion, then you have to tell them that you're doing that. But I would have thought that this would be prohibited, but it's not. One can, under the regulation as proposed, do this, but you have to tell people that you're doing it. So that's what it means, transparency obligations. You have to tell the subject of the AI, the person on whom the AI is being applied, so not the user, but the end subject, you have to tell them that they're being subject to AI. And safety. The key one, the most important one, is high-risk applications, and they are anything that's covered by EU safety legislation. Toys, cars, lifts, medical devices. I mean, the kind of things that can be quite dangerous if they are wrong. So if you have an AI in a car, in a self-driving car, that is seen as a high-risk component. And there's a whole raft of EU safety regulation that goes along this, and that if you make a car with self-driving AI, you need to comply both with the car regulation and with the AI regulation. But more interestingly, and what's new, is these other categories of applications on the right. So anything that's used in biometric identification, critical infrastructure, education, like the example that I had, employment, so recruiting people, public services, so giving benefits to people, anything to do with law enforcement, predictive policing, that kind of stuff. Immigration, so making asylum decisions on the basis of AI, or justice system. There was a system in the US where AI was being used to calculate the risk of people running away if they were released, and that was this kind of application is high risk. So high risk is what we're going to look at now. That's the interesting one. It's that category there in sort of deep pink, and this is where companies have quite high burdens that they have to comply with. And this is done on the basis of the so-called new legislative framework, which is the way in which the EU regulates products is effectively to put the burden on the manufacturer of that product. And this is the philosophy behind it. The manufacturer, having detailed knowledge of the design and production process, is best placed to carry out a complete conformity assessment procedure. And conformity assessment should therefore remain the obligation of the manufacturer alone. So this means that the AI, in this case the provider, is the entity that's got the bulk of the responsibility to make sure that these high-risk systems comply with the requirements in the Act. And these obligations are extremely extensive. So they include establish a suitable risk management system. This means, in the words of the Act, a continuous iterative process run throughout the entire life cycle of the high-risk system, requiring regular system updating. So this is a sort of cradle-to-grave obligation on the provider, not just before marketing it, ex ante conformity assessment, but even after you market it, you still need to check that it is complying with the obligations of the Act throughout its life cycle. You need to identify for known and foreseeable risks. You need to identify a suitable risk management measure, design risk management systems so that any risks entailed are eliminated as far as possible and any residual risks are acceptable. So this is both very extensive and also leaves a lot of discretion on the companies. Companies will have to decide for themselves what is a suitable risk management system, what is elimination as far as possible, what is an acceptable residual risk. These are very difficult, controversial questions that companies will be asked to engage with. And there's obligations concerning data governance. For instance, they need to make sure that any both training and testing and validation data sets are relevant, representative, free of errors, and complete. I don't know if any of you have had anything to do with data sets or worked in this, but a data set that's free of errors, I don't think has ever been produced by a human being. So this is a very high barrier. There's all kinds of pushback from industry about these unreasonable, I think, demands on industry. But it gives you a flavor of the kind of very extensive obligations that this regulation imposes. there's of course obligation to draw up technical documentation, so be very transparent and open on how things are made. There's obligations to have logs. Again, this is nothing new but still it's there. Systems need to be transparent and interpretable so that they can be overseen effectively. Sorry, there was a question there that came up. Daria, do you want to just see whether that's something I should take up now?
Thank you, Professor. Wow, so interesting lecture. You know, I listened very carefully each of your words, and I think that yes, we have to look on our chart. Let me see. Okay, so we see the comment from Juan Sonmin, probably when you was talking about AI, right? And just example of USA and social scoring system in China, there's some comment that such prohibited applications means that most fantastic AI developed in USA is not acceptable, such as social scoring.
Yeah,
okay,
I mean,
USA, China, sorry, there was error. So probably student was talking about the Chinese example about social scoring system.
It will be. I mean, it obviously the extraterritorial effect doesn't prevent it being used and deployed in other jurisdictions, but it means that it can't be used and deployed in any of the EU member states. So that's a decision that the EU is making. There's no controversy that I've seen about that being as a prohibited application. So it's very likely that this will stay in the final version of the Act, which means that yes, this kind of AI system will not be permitted to be deployed in EU member states.
Thank you. And we have also probably a question related to risks. Also from Juan Sonmin, in new context, there is no black box AI, so some AI technology cannot be used in European Union. Is it true? What do you think?
Yes, I think there's very high demands on explainability, interpretability, and transparency, so as to be able to allow for effective human oversight. So whilst we know that, say, neural networks have to some extent a black box element to it, nonetheless there should be sufficient information about the kind of parameters that go into the system, the kind of training data that's used, the objectives that are sort of set into the system, so that there will be some degree of effective human oversight. So complete black box systems will not be allowed. Okay, if I can move on now, one interesting aspect there is the requirement to provide relevant instructions for use. That means that AI providers will need to draft detailed instructions so that the users can operate the AI in a way that complies with the requirements of the Act. And those instructions will be binding, prima facie at least, on the users. So in this way, companies that design AI and provide it to users will effectively legislate for how that AI is to be used. So they will provide legally binding instructions for the users of that AI. And just to follow on from the complexity, to give a flavor of the complexity of the task facing AI providers in complying with this proposed regulation. This is not something, these tasks are not something that, say, you can leave, a company can leave to an engineer or to a group of engineers. You need to have a very wide range of professionals in the company that will be able to understand the requirements, see what they mean in practice, both from a legal point of view, from a technical point of view, from a compliance and risk point of view. And so what McKinsey Consultancy, this is a sort of big multinational consultancy firm, they are saying already companies engaged in AI should already start to think, how can we comply with this new AI regulation, and should start to put the processes in place that will allow for compliance. And what they suggest is the setting up of a cross-functional team of technical, risk, and legal professionals to set developments and deployment standards and to monitor compliance. Excuse me. So you can see that this is effectively asking companies to create legislators internally that will set standards that will bind the company itself. So an internal process, an internal system that will impose standards that will allow the AI to comply with the requirements of the regulation, and then everybody in that company will need to comply with the standards that have been set by this team. And these are highly complex decisions, and it entails potentially very controversial questions of, as I said, what is an adequate level of risk? What is a suitable management system? These are questions that we don't have a lot of guidance, and we don't have a lot of materials to go with. There will be an explanatory report that will come with the AI regulation that will provide some degree of guidance. There will be also, if I'll talk about the enforcement system, but there will be an EU data protection AI board that will also help and provide guidance on what is proper standards. But companies are going to have to do a lot of the spade work themselves, because ultimately it will be the companies, and this is on, again, just for high-risk AIs, and also high-risk AIs which are not already covered by some other regulatory safety regulation systems, such as if you're making the AI to use in lifts or cars or toys, there's already a conformative process in there. But if you're making AI that doesn't fall under those categories, but it is still high risk, say you're making AI for an educational system, as the example that I gave, then it'll be the provider itself that will need to put the quality management in place and then certify, self-certify that the AI that it is putting into the market is in conformity with the obligations in the regulation. And it'll be the company itself, the provider, that will issue the EU Declaration of Conformity. So this is quite an obligation and quite a power that companies are being assigned under this regulation. Even after the product is out there and is marketed, then it'll be up to the providers to establish and document a post-market monitoring system to actively and systematically collect, document, and analyze relevant data provided by users throughout the lifetime of the AI, and allow the provider to evaluate the continuous compliance of AI systems with the requirements of the AI Act. So you can see that there's a lot of obligations before putting it into the market. Then there's the obligation to put the stamp saying that the conformity assessment has been carried out and that it's guaranteeing the provider needs to guarantee that the AI complies with the AI Act. And then even after the product is marketed, there's an obligation on the provider to actively and systematically monitor the performance of the high-risk AI system throughout the lifetime of that system and to evaluate its continuous compliance with the requirements of the Act. So what is there to help providers? Well, and also what penalties are there? How is this going to be enforced? The European Artificial Intelligence Board will not have an enforcement power. So there isn't an EU enforcer in the way that there is for, say, competition law. But the European Artificial Intelligence Board can draw up guidelines, help national authorities coordinate, provide advice, guidance, etc. There's also the national competent authorities. Sorry about this. I'll just need to turn that off. There's also the national competent authorities, which in all likelihood, it'll be national competition authorities that'll be charged with the market monitoring and ensuring that AI products and systems are compliant. And these national competent authorities will have the powers to require any provider to take corrective action, say to fix any AI that might not comply with the AI Act, to withdraw the product from the market if it's seen to be a prohibited product or if it is not compliant with the requirements of the Act. And if there's a breach of the Act by a company, then the company is subject to fines of up to 30 million euros or up to 6% of its total worldwide turnover, whichever is higher. So if you have a company like Microsoft or Apple or Google that breaches the AI Act and they have a worldwide turnover of several $billion, then you can see that the fines go up to even more than the fines that are available in the GDPR. So these are very tough penalties. And I suppose there's a question of why is it so expensive? Well, I think it's a bit like in the Middle Ages. There wasn't a police force, but if you got caught stealing sheep, you would get hanged. So you have very tough penalties. There's not a lot of enforcement procedures. There's not a lot of police out there. But if you do get it wrong, if you don't self-police properly, then there will be very tough penalties. So this gives an encouragement for companies to make sure that they comply. They don't put any products on the market that they're not sure will comply with the requirements of the Act. Of course, these are upper levels. So this will be for gross breaches that cause a lot of harm and that show a sort of very high disregard for the regulation. It's not necessarily sort of just making a mistake that will lead to these very heavy penalties. But they are heavy penalties. They're even a bit heavier than the GDPR, as I said. And now just to finish, just thinking about this in a wider context of the EU's engagement with the digital world. The EU has the objective of creating the internal market, as I said, and part of that is to create the online internal market, the digital market. In order to create this market where products and services and people can move and interact freely, but also in a way that is safe and protects fundamental interests and fundamental rights, then the EU hasn't just introduced this EU AI Act, but also already the General Data Protection Regulation, the Digital Services Act and Digital Markets Act that have just come into force and now are coming on stream, the e-evidence regulation, the Data Governance Act, the Cybersecurity Act, and others. Also the AI Liability Act is going to come in as well. The AI Liability Directive is going to come in as well. But what a lot of these instruments have in common is that they place a great deal of responsibility on the market actors themselves, in particular companies which play an important role in either providing AI services or AI products, or they have some kind of other important role on the digital world. So the Digital Services Act places particular burdens on gatekeeper services, so services that allow access to online services such as Amazon or Facebook or Google. And this is to some extent a continuation of a previous trend, but it's one could say an aggravation of this idea that companies are being put in a position where they are being required to effectively regulate aspects of the market and aspects of society. So there's the obligation to balance interests, to make sure that certain interests such as protection of fundamental rights are respected, or to, in the case of the e-evidence regulation, to balance on the one hand the privacy rights of individuals and the need of access to evidence of crime investigation agencies. So these are very extensive and very broad obligations that the EU is placing on companies, and it's placing them not just on companies in the EU, but also companies that are based outside the EU, but that might wish to trade with or provide services with into the EU. So that I will leave it there. That's the end of the, I will stop sharing it. So I think that this is an interesting and unusual development, perhaps a worrying development, but certainly something that everybody that is interested in our online world and the regulation of our online world should be aware of and should be thinking about and should be keeping abreast of to some extent, whether you're in the EU or not. I will put my camera on. Sorry, I hadn't realized I'd had my camera off. Sorry, but anyway, you were looking at the PowerPoint, but now we can look at each other.
Yeah, Professor, thank you so much for this very large point of view. I think that we knew today a lot of things about AI, about European law, and what the main objectives of European Union in general. You know, like now before us, we'll ask the questions from the audience. I propose to start first to ask you. You know, I realized that Taiwan is one of the largest partner for European Union for trade of goods. Do you think that due to that, of course, there's a lot of investments, both from Taiwan, from European Union countries, and talking about the trade of AI. Of course, this regulation will come into forms, and Taiwan also will have difficulties to comply with a lot of new requirements in order to achieve trade purpose of AI to European Union countries. Do you think what main difficulties will be for Taiwanese audience to comply with AI Act? What the main articles or main provisions Taiwanese audience have to bear in mind in order just to make the emergency steps of compliance. Because of course, for the start point of view, when AI Act will come into force, there have to be some, like the main steps for compliance. Do you have some recommendations about this kind of steps for Taiwanese audience?
I mean, I think the first step is to check whether you're going to be a provider of AI. So check whether the system, whether you are developing the system or supplying it under your own brand. So for instance, if Apple develops a system and it's manufactured in Taiwan and sent to Europe, it's under the Apple trademark, then it's likely that the provider will be Apple. So you can leave it to Apple to worry about the compliance with the data protection, with the AI Act. On the other hand, if there is a system that is marketed under the brand of a Taiwanese company and supplied under the brand of a Taiwanese company, then that company needs to check, is this an high-risk system, or is it a prohibited system, or is it a limited risk system where I just need to introduce these transparency obligations? And then if it is a high-risk system, then figure out how to comply with the requirements. I think it's going to take a lot of work. This is, as McKinsey suggests, this is going to need teams of people, compliance people, legal, risk, technical staff, to check what the AI regulation requires and how it can be complied with. I saw there was there's been some comments and questions in the chat. Why is this so expensive? Is this not just a burden on companies? I agree that this is an extremely onerous and extremely demanding regulation. I can tell you that industry in Europe is engaged in the process of communicating their views to the Commission. It's also a process that's open to Taiwanese companies. So although you don't have members of parliament and so on, you can certainly, a Taiwanese company can certainly communicate with the Commission and inform them of their views, because the Commission is still there and it will have to pay due attention to the views of important trading partners, because the EU has this ideal of free and open trading, not just within the EU, but also at the global level. And if the EU is seen to be imposing unreasonable restrictions on movement of services and goods into the territory of the EU, then that will undermine one of its core values and core objectives. So I think there is a role for actors outside the EU to inform the EU of how this will affect them and what that means for the trade between, say, Taiwan and the EU. But yes, I think that what McKinsey consultancy says is companies need to start thinking about it already. So they need to start doing an inventory of the AI services that they provide, where they are providers, and then assessing which ones are high risk, and then having a think about how can we make sure that these high risk systems comply. So there's work there for the companies to do, unfortunately, perhaps.
Yeah, you're right. It sounds like a lot of work to do with new Artificial Intelligence Act in the future, and I believe you rightly say that the actions have to be implemented already now, maybe not only for Taiwan, but for all partners of European Union who are the partner for trade, let's say. I think there have to be really some negotiation negotiation steps between European Union and the members as the partners for AI development or AI trade. And I see in our chat there is another questions. Let me just read these questions. There is thanks for you, Professor Gill-Pedro, for an amazing lecture. And on the other hand, there is wonder if the AI Act is passed, will it create new type of compliance professionals? In your school or other European school, do schools begin to provide courses training these professionals?
Yeah, that's a very good question. And yes, I think that this is something that's going to permeate through all areas of the industry. And that includes the training of engineers, the training of compliance officers, the training of lawyers. There are a lot of seminars being organized by organizations like the Small and Medium Enterprise Association of Europe, for instance, and trade organizations, civil society organizations, certainly at the academic level here at the university, we're in discussions about having graduate courses, undergraduate courses, elements brought into the curriculum to allow us to be up to speed on the new rules when they come in. Like I said, they're not in force yet. They're not going to be coming into force even when the AI Act is passed. My guess will be probably January 2024. That's my guess. You heard it here first. But it is a very complex negotiation. There's still a lot of unresolved points. But even if it is passed then, it'll not be law until 2 years after it is passed. And that means 2026. So there is time, and that's for all elements of society. You know, government might need, generally, member states are not allowed to regulate in order to implement regulations. You know, the idea is regulations that are directly applicable and member states should not interpose their own laws, but certainly having guidelines and laws about how national authorities operate, how say universities operate. We are going to be users of AI systems that are going to be regulated by this. Maybe even some universities and other public authorities, research centers are going to be providers. You know, here we have quite a big research on AI, and we need to start thinking about it at Lund University, and the Swedish government needs to do that, and local authorities need to do that. So it's all levels of society will need to engage with what this regulation means for them.
Thank you for your expertise in this question, dear Professor. And we have the last question in our chat. How did the European Union decide to categorize AI technology into 4 levels? For example, why biometric technology is categorized into high risk but not other level?
Yeah. Biometric identification is seen, especially when it's done by public authorities, is seen in Europe to be particularly problematic. There's this idea of, there's this famous book by George Orwell, 1984, where there's this idea of Big Brother watching you. And I think having the public authorities identify individuals, use facial recognition or other biometric identification and track them is seen as problematic. Other kinds of, so for instance, I mean, my phone, I can unlock it using my fingerprint. That's normally, you know, that's biometric identification, and that's going to be limit or no risk at all. It's going to be sort of the lower category. So not all biometric identification are going to be problematic, but some kinds of biometric identification are going to be either prohibited or they're going to be considered to be high risk, because there is a certain concern this is a political matter in the EU and perhaps a cultural matter in the member states, that the use of this type of technology, in particular by state authorities and law enforcement authorities, is problematic from a civil liberties point of view and a fundamental rights point of view. And so the Commission in this is responding to sentiment that it considers it exists already in the EU. And it'll be, of course, then up to the EU legislator, the Parliament representing the citizens and the Council representing the governments, that will ultimately decide whether this is the case. But my reading of the debate is that they want more, certainly Parliament wants tighter restrictions on biometric identification. So there seems to be very broad support amongst the representatives of the EU citizens through Parliament, very broad support for very tight restrictions on the use of biometric identification in AI. I hope that answers the question.
Yes, I believe so. I agree with you, and I believe the differentiation of AI, whether is it like first level, second level, and third level or fourth level, always can be depend up to country. Like probably like in USA, Taiwan, China, European countries, these levels can be understandable on different points of view, right? Like up to how this technology is practiced in reality. So of course, this can be truly problematic to understand for other countries, these levels and this differentiation. But
they are very culturally specific.
But I also seen that a lot of experts have been invited in order to provide this AI Act as best as the European Commission can. So I believe from the technical point of view, of course, these levels also was like, divided. Of course, there was been invited technical experts. So I believe it's also question for technicians can be addressed as well. Thank you so much, Professor, for this amazing lecture. I really enjoyed, and I got a lot of new knowledges. I'm glad that we have the audience that also ask you about this AI regulation. And now it's already 9 p.m. in Taiwan and 3 p.m. in Sweden. So I really believe that in Taiwan there's time to sleep, in Sweden probably time to have preparation for the dinner.
Yes.
Thank you
very
so
much. It's been a pleasure. Thank you for all the questions to all of you.
Thank you, Professor,
Bye.
and thank you for audience, and thank you for the National陽明交通University School of Law for the support and host this online event. Thank you so much. See you next time.
It's been a privilege.
Bye-bye.